all, thank you very much for the very kind invitation to this very important, I think, seminar on essentially derived varieties. I give it a bit from a different perspective. I'm not someone I'm not a breeder. I'm actually a lawyer, which is even make it worse, I think, even. I'm a lawyer, and my title might say Biomedical Innovation Law, which is what I do most of the time. I'm involved in a lot of human biomedical stuff, but I also have one of my hobbies is plant-related IP, and that's what I'm going to talk about today. So let me introduce it, but let me build up a bit of a story here. And that is, why do we have plant variety protection in the first place? Because people might think, well, it's one of these obscure intellectual property rights. Well, I think actually it's a very, very useful system to have, and I think it's indispensable, to be honest, to have it if we want to stimulate innovation in plants for a number of reasons. Because one of the fundamental things that no other intellectual property right that could be suitable for plants allows is that you have access to the material, which obviously patents do not give. And that's obviously in the context of breeding very important. There is, of course, a form of IP protection, which means that it stimulates innovation if we believe those basic principles, so there is some kind of quid pro quo. It's a relatively low cost. I mean, most of you who are probably involved in patents know that it's not exactly cheap business, patents, and once the lawyers get involved, it becomes even more expensive. And it does normally not have a prohibitively wide scope, as sometimes is the case with patents. So, as such, it looks like a perfect scheme for breeders to use. But then, of course, there's a little detail which is called essentially derived varieties. And that has been a bit more complex. And I'm not going to go in all the details of the provision. As you can see, it fills a full slide in a small font, so that already gives you some idea of how complex it is, because there's a rule, if you have to use a lot of words to explain something, then it's probably not very easy. There is a lot of words here used. As I said, I assume that all of you are specialized enough in the area to know what the concept says in the treaty, so I'm not going to deal with it in detail. There's three criteria that are mentioned in the statute. Unfortunately, I have to say, none of them are clear. There's no clear definitions in the statute, which is, of course, not something which is extremely unique to the plant variety rights system. It's very common in treaties that principles are not exhaustively defined, so I don't see it as something extremely surprising. Of course, it always provides to some extent, some legal uncertainty. There is some examples even given in the treaty in the UPOV 1991 as to what an EDV could be, and there's a number of examples at the bottom of my slide. So it could be a selection of a natural induced mutant or a somoclonal variant, and so on and so on. So these are examples, but obviously it's not exhaustive, so there could be more that could fall within that principle. How does it then work? Most of you probably know, of course, but just a small reminder. How does it work? Well, if all the normal protection requirements are fulfilled, then the breeder of an essentially derived variety gets a right, but obviously he may assert all his rights himself. However, if you're the owner of the original variety, then you have some kind of right against the essentially derived variety holder. Which is, of course, a limitation, which is a kind of an extension of the scope beyond the variety you have the rights for. And that, the reason why I say that is, will materialize to be quite important later on in my talk. So why do we have EDVs? So why has the concept in fact been introduced? Because as you know, it has been introduced in 1991. I think it's also always useful to remember why things have been put into place. And it is that plant breeding is an incremental and iterative process. Plant breeders use and build on the work of previous plant breeders and rely on existing plant varieties for the initial source of genetic variation. And then there's a number of common plant breeding techniques which are being used. And that process, that incremental process, is very much supported by the UPOV system, which would not necessarily be supported, of course, in other intellectual property rights, such as patents, where normally, of course, there is no access to the material as such for the breeding. To the extent that we don't have a limited breeders exemption, of course. Some of us in Europe at least have it. So there's obviously a reason why EDVs have been put in place, because the problem was, if you have one of the foundational principles of the UPOV system is full breeders exemption. So anyone can use a protected variety and then eventually also bring his or her new variety on the market. That is quite unique because no other intellectual property right has that. But it obviously also provides a slight hiccup potentially, and that is if you have an intellectual property right on something, you cannot necessarily prevent, or you cannot prevent any third party from using that variety to develop their own new variety. So it limits your enforceability of your right, which is of course not the case in other intellectual property rights where you have an immediate enforcement. No one can use without your consent, whilst of course in plant variety rights that is the case. And as a consequence, of course, coming closer to 1991, I think more and more breeders thought, well, what is the value of a plant variety right if there's no way how we can enforce it apart from enforcing it against someone who is basically producing products that are the same variety. To what extent does it protect our innovation if we can't prevent anyone from using our material and doing something, developing something that's slightly different? And so there was a kind of I think, not a consensus, but there was some kind of, idea that we should move on towards an area where there was a slightly stronger form of protection for plant variety rights, and hence came the concept of EDVs. Because that gives a fairer protection for right holders, and it also tries to prevent free riding by third parties. So obviously, as I said, the full breeders exemption was not easy to reconcile with an effective protection, so as a consequence something had to be done, and the EDV was the concept that was then used in order to achieve that. Also, I think it's important to realize that, because people sometimes say, well, I mean, it's only a small change, who will be hurt? Well, that's not the case, as probably most of you will know. A small change can have enormous economic effects, and a very interesting case is actually an old competition law case in the European Union, the Pitikakiria case, where actually the Commission in its decision said that here, for example, in the horticultural and floral sphere, a mutation or a creation can become a bestseller overnight. So basically you make a small mutation and have immediately a bestseller product, and you basically wipe out the entire original, maybe the market for the original right holder. And obviously that's a problem if there's no way how you can enforce that, your own right against someone who is doing a slight distinctive thing from yours. And as a consequence, I think it is important that we have a concept that extends the scope of protection to something more than this product itself. But then how far do you have to go? And that's of course the difficult detail. I give here also kind of a theoretical example. If you have an insecticide-resistant orange, for example, that has been the subject of a PVR or a PBR, then a second breeder can change the leaf color, and as a consequence you might say, well, you know what, it's not the same, I have a new variety. But is it an essentially derived variety or not? Well, if it would not be considered to be an essentially derived variety, then obviously purely changing the leaf color might be enough to escape scope of protection of the plant variety right, and that's obviously not what most people want to spend their money on in innovation in oranges, and then see that someone changed the color and obviously there it all goes. So is that what you want? No, you don't want that. So you want to have some room of maneuver and some scope for your EDV concept. Also a reason why I think it was necessary to develop a concept such as EDV is because patents have become more popular. Also because they gave a wider scope. They're obviously not for everyone because they're quite expensive, but they gave a wider scope of protection. So some people say, well, if we can't get a decent scope on the plant variety rights, we go to something else. Because there on the patent law you have equivalence or other kinds of things. It's more than what you've literally protected. So then comes the key question: how to implement EDVs? Well, that's not easy, as UPOV has realized themselves as well. It's quite a tricky thing, and I don't think there's anything exceptional in being tricky, because, I mean, in all fairness, I have to say that I'm knowledgeable about patent law as well, at least I hope I am. we have this doctrine of equivalence in patent law, which means that the scope of protection extends beyond what is just literally claimed. We don't fully know in all countries what that exactly entails. There's still Supreme Court case law on a regular basis. So it's not that a concept has to be absolutely crystal clear from the very first moment it has been created. So I don't think it's abnormal that it's not absolutely clear, but I think it's important that it becomes clear. And it's important that there is guidance given to users of the system as to what the extent of EDV is. And there's two ways how you can deal with it. You can say, well, a very narrow interpretation, in which you say, well, it's only one or two minor differences, and if that is not happening, then you're outside of the scope, then it's not an EDV anymore. Sometimes that's also been labeled as plagiarism. As I will say later on, I'm not a big fan of the word plagiarism. I think it's slightly ill-conceived, but I will explain that later. I'm a lawyer and always legal arguments in order to prove that, of course. I will not deal in detail with the UPOV explanatory notes. I assume that you have taken knowledge or have taken access to those and know these things. I don't think it's very useful to go to these very detailed explanatory notes, which I think are useful but probably are not providing the legal certainty that I was hoping they would have provided, and probably users as well. But what you can see is, my view, and I might be wrong, my view is that probably these explanatory notes seem to suggest a rather narrow interpretation of the EDV concept, because they say in paragraph 10 it should only be one or very few of those differences. And that is, in my view, slightly problematic, because if you give this narrow interpretation for reasons that I will explain later, I don't think it gives justification to the rationale of why the concept was introduced, and I'll explain that later. So I can already say now that, in my view, the idea of limiting EDVs to one or very few and associating it with the term plagiarism is, I said, ill-conceived, and I don't think it's a proper interpretation of the convention. But I also think that using the word plagiarism is quite confusing, because I'm an intellectual property lawyer, which means I know my intellectual property rights and all of them, and people who think that the term plagiarism is narrow, it's not. So what I've been doing then is I looked at what's the rationale of the 1991 convention. Why was it created? It was to strengthen the rights of breeders. That was very important. Thank you very much. It was a very important rationale for creating this new treaty. And then I looked also, which a lawyer is traditionally doing, I tried to interpret the treaty. And one of the standard means of interpreting the meaning of treaty provisions is using the Vienna Treaty and the law of treaties. And then you look at the preparatory works, you look at the text, and then it gives you some idea of what was meant. And so it's clear, very clear, that the rationale was to strengthen the rights of breeders. There was also actually, if you look at the preparatory works, a proposal to limit the scope of EDV to very limited number of modifications, as literally mentioned in a proposal. But that was, by a large majority, rejected. So if you look at the preparatory works, it is clear from those already that the interpretation of EDV can never have been meant to be very narrow, because it's against the rationale of the system and against something that has been specifically excluded as a proposal to be accepted. So, and to the extent that people would associate the word plagiarism with only a few differences, I think that term should not be used to interpret EDVs. I personally think that the word plagiarism is not limited to only a few differences, because if you look at where it comes from, copyright law, plagiarism is far from being limited to only a few minor differences. So, and I've seen this word has crept in, and everyone kept on using it suddenly in the literature without asking themselves any questions about it, because probably everyone copied it from the other one, whilst we're in the sector of copying. But no one has been asking themselves questions. I thought, well, I can only find out when I look at the preparatory works, and then I found it doesn't make any, it's not how it should be. So, as I said, plagiarism is not equivalent to a very small number of modifications. And then secondly, when I was thinking about that, I also thought, you know what? There is not one single intellectual property right we can think of that limits its scope to only a very small number of differences, because it's an inherent feature of intellectual property rights that they have the tendency to extend the scope. And I can give you examples in all intellectual property rights. The scope of copyright law has expanded over the years by interpreting the concept of copyright infringement or plagiarism. In trademark law, we have concepts such as confusing similarity and negative effect on the reputation of a trademark, which is a means to extend scope of protection of a trademark. We have design law, where the concept is there is infringement if it gives the same overall impression, which means it's not the same. It must be quite similar, but not the same. In patent law, we have equivalence. So all intellectual property rights, by definition, have the tendency to give a scope that goes beyond what is literally there. And it goes quite far beyond. And I think it would be unrealistic to assume that plant right protection should be the exception to that, because of course there's no reason. Also, there's no rationale in the treaty itself to that effect. So if you have no rationale in the treaty, and all other intellectual property rights have the tendency to do the same, then I think there's no way of escaping that you should do similar things and give it a wider scope. So that's my view on it, of course. And then I always use this example of the Arctic apple, which of course there's two ways how you can look at it. You can say that the Arctic apple is of course an essentially derived variety in the one hand, because it basically uses most of the characteristics of the original variety and it adds something. But you can also say it's not an EDV because it contains an important characteristic which differentiates itself from the initial variety. And that's of course, that summarizes the problem. How far are we going to go in interpreting the EDV concept? And obviously, I see people looking at me like he's going to give us the evangelical answer that we can all take home with, and we can now all wrap up now after my speech and have a long coffee break. Unfortunately, I have to disappoint you on that. It's probably not going to happen now. I mean, I'm a very modest man, so it's not going to happen. I'm probably not going to give you the solution. I've already given you something which is definitely not the solution. So for those of you who have incorporated that in their practice, I think you should do away with that at least. So that's already a first positive advice. The second positive advice is, I think, this conference, which I'm very pleased to talk on, I think, also for me, is to initiate a new discussion on what is the way forward, and that's how I should like to go to. And that is, well, in my view, a very narrow interpretation is not tenable, it's not in line with the rationale, plus I think it doesn't give what users want. And one of the things that we may not forget, I think, is intellectual property rights are not there only for legislators to make and for organizations to read and for academics to study. They're there for users to be used. It's very important, of course. If you make an intellectual property rights system that users don't want, then you make yourself irrelevant. And no one wants that. And I'm pretty sure that UPOV doesn't want it either, of course. And I personally think that plant rights are a very important right, because I think for a lot of people in the room here who are breeders, patents is not necessarily the solution, because it's very expensive, it gives a very wide scope of protection, it doesn't have the full breeders exemption capabilities, so it provides, so it limits access. So all these kind of things, to some extent at least. So to some extent I think it's a very good right to have, but you can only maintain it if it remains relevant for the users. You live and die by the users. Every piece of legislation should know that, of course. So how do you make it relevant, or how do you make it more relevant? Well, that's why I've done like an intellectual exercise, and as I said, for those of you who thought I was going to give you the final solution, it's not going to happen. But I've been using it's purely an intellectual exercise in the sense that I try to give some kind of start of a discussion. And there's two ways how you can look at it. One of them is based on patent law and the doctrine of equivalence, not surprisingly enough. The reason why I used patent law, because people have always said, plant variety rights is a very special kind of system because it combines science, law, and other things, and economy. Well, basically, patents is doing exactly the same thing. So it's not that unique, you know. It is basically fundamentally a similar kind of right. So we have a doctrine of equivalence, and I'm not here to tell you or to advise you to copy the doctrine of equivalence into EDVs, not at all, but I'm here to tell you that there is maybe a way to start a discussion there in taking inspiration from those kind of concepts. So don't see whatever I write down in my slides as being the Bible and you have to take it or leave it. It's the start of a discussion. How can this take us forward, further forward, to give a more fair, reasonable, and workable system. And I'm not going to go, I think it would be not very useful, I think, also in view of my limited time, in take you through all these intricate details, because some of you might not necessarily be highly specialized in the doctrine of equivalence on the patent law, and that's a nightmare in itself. If you thought that was only EDVs were a nightmare, I can tell there's other nightmares in the world, and in the world of intellectual property. Actually, I don't know many things in IP which are not nightmares. I probably chose the wrong subject when I decided to go into IP many years ago, but it's fascinating. So I'm always intrigued I'm fascinated by difficult things. As I said, it could be the start of a discussion, because what you try to do in the doctrine of equivalence is you try to evaluate to what extent something that is not the same as what you protected, but is slightly different, but is largely based on what you have protected. How can you then still claim protection for that? And there is a number of ways how this has been implemented in the case law. And there's quite a few different ways how it has been implemented into case law. One of them, for example, is the function-aware result test, which says if something is done in essentially the same way to achieve essentially the same result, then it's an infringing activity. And then you can, as I said, it's not copy-paste one-to-one to plant variety rights, I think, but you can use that as an inspiration to say, well, you know what? What in case someone makes a variety that is essentially based on an original variety? And of course he will add something new. He will change the color or something, which of course I know for certain, in certain areas is very important. Well, is it then, because you basically use almost all the essential features of the existing variety, should you then be able to just get away with it because you changed the color? Or should you say, you know, this is probably essentially derived, is it? Because under patent law, this would probably be equivalent, because it's largely based upon it. That could be one way of looking at it, and I don't say it's one or the other. There's a second way, and it could be combined actually with another test, and that is Jerome Reachman. Many years ago, he said there's too many patents in the world, which is a fact, and there's too many patents in the world that should never have been granted, and it's called then sub-patentable inventions. And he said we should do away with that. We shouldn't have all these patents anymore, and we should replace these sub-patentable inventions, which he called a liability regime system, in which you don't prevent, let's say, people who derive their wisdom largely from someone else from producing those products, but they should pay you for it. So let's try to apply that to plant variety rights. I have an original variety, and someone is deriving that largely from me as the original variety right holder. Well, he can do that, and he can commercialize, but he has to pay me part of the proceedings. Part of the profits have come to me. So kind of a forced license, basically, what you introduce. So that's, of course, a pragmatic way of escaping lengthy discussions about, okay, how are we going to deal with it? I don't think it can exist in itself as well. I think it's, as I said, I think everything will probably have to be a combination of a test, hopefully devised by UPOV, combined maybe with a liability regime or just a test. But I think there's ways forward. And I think looking at other intellectual property rights, how they have solved very similar existing problems, as I said, it's not unique to plant variety rights. We have someone who ripping off someone else's innovation, and that's common. That's human nature, I would say. So it happens in all intellectual property rights. But we have to try to create legal certainty. Absolute legal certainty doesn't exist. Next week I have to give a speech on gene editing somewhere, and people are going to say, well, we want absolute legal certainty, otherwise we can't, it's a GMO. Well, there's no such thing as absolute legal certainty. If you want absolute legal certainty, you have to lock yourself up in your house and hope that the ceiling doesn't come down, because even then you're in trouble. So there is no such thing as absolute legal certainty, but you can make it, you can come closer to it. So what I would suggest, and obviously that has been happening now already for many years, is that UPOV gets into dialogue with users of the system, and they can be inspired by what I said or not being inspired. I mean, I'm a very humble man, so people cannot be inspired by what I said, and say, you know, how do other intellectual property rights do it? How have they come to very similar, how have they solved very similar problems? Because everyone has the same problem. I spend money on my innovation, I want to have a market, and I have someone ripping me off. by using largely my invention and adding something in a cheap way. Well, there is a way out of that, of course, and other intellectual property rights have solved that. So a doctrine of equivalence type of test, I think, might be a solution. Obviously, it will have to be amended, and I'm very happy to help anyone in creating anything or to give my assistance to the extent that it would be welcomed. But I think that's the way forward, I think, that we look at how is it done in other intellectual property rights. They have managed to do it, so it must be possible for us as well. I think plagiarism, because I don't like the word plagiarism, as I already said, because it doesn't make any sense, because plagiarism is not the same as very narrow, because I know my copyright law. And also I think it doesn't give fair protection, because one of the reasons why I mentioned all the other intellectual property rights, one of the reasons why intellectual property rights go beyond the literal protection is because we have this fundamental concept we all agree upon as human beings, and that is fairness. And we think that people who spend money on helping us to get better products, more beautiful products, whatever, they deserve to be rewarded for that. But they only deserve to be rewarded for that if the reward can be made. And if the reward is ripped off, then it's not the proper reward. And I know some people will say, yeah, but that's patent law talk, and all these people who want expansive scope of protection. No, that's not what I'm talking about. I'm talking about a fair reward for someone. And that should be the starting point. And then you can discuss further. And with that, I think, I would like almost to conclude, because I'm actually run out of time, I think. Or apparently I'm perfectly on time, which, I mean, people already laughed at me before when I came in, that they say, well, you're the challenge. I mean, well, look now. Everyone can learn. So conclusion and summarizing as well. Rationale of the 1991 version was to strengthen breeders' rights. EDV was introduced because of the complexities of the system, because you have a full breeders exemption, which makes it difficult to enforce your rights. So if you want to have a fair protection, you need to do something. EDV was conceived to that effect. A very narrow interpretation, in my view, doesn't give a fair protection to users, and it's not the way forward. A slightly wider protection is definitely feasible because it's in line with other intellectual property rights that have managed to do it, so it's definitely possible. My view, you can do a combination of looking at maybe what patent law is doing in the doctrine of equivalence and adapting it, of course, to the framework of plant variety rights. Or if you want to look at a more licensing-based scheme, that you say, okay, let's not go into complex things that what is exactly one is it an EDV and one is it not. We have the EDV concept, but we create something which is called then a liability regime, in which we say you can use it, but you have to pay part of the proceeding. You will still have to know what an EDV is. As I said, it's not an or. It will be a combination of a test that improves on the current guidelines, combined or not with a liability regime. I leave that open for discussion, of course, because we don't have a liability regime as it is here, as I've proposed in patent law and in no other intellectual property rights, so that would be a bit unique, of course. So with that, I actually end my presentation. Thank you very much for your attention.